I want to spend a few minutes talking about how living trusts protect your heirs, or at least I want to talk about how you can use a living trust to protect your heirs. One of the common mistakes that I see people make in their estate planning, and this is true whether it's a will-based plan or a living trust plan, is providing a distribution to heirs that give the assets outright to the heirs when the client passes. And the reason I say that that's a mistake is because, we've been at this a long time here, and we know that out in the world there are predators, there are creditors, there are fortune hunters. We have seen real experiences with our clients. We know that we're not making this up. These are real issues. We have adult children that are spendthrifts. Whatever they inherit, it will end up being spent. Our clients who are the parents usually know that that's the case. We have younger children. They're still too young. They've not developed a level of maturity they're just too young to hand over any meaningful amount of assets to manage. We have in-law issues. And one of the things that we know is that in every marriage there's at least the potential of a divorce, and if a divorce happens, one of the risks that you have is that the assets that your heir inherited from you are at risk of being lost in that divorce because they've been commingled with other assets. That's a very common occurrence. The other thing that can happen is that your heirs can be sued by somebody, rightly or wrongly, but your heirs can end up with judgment creditors who have the right to come in and levy on and just take away the assets that your heir has. And so I've created some slides here that maybe exaggerate the problem a little bit, but I have some clients who would say I'm not exaggerating this. But let me just talk for a minute about your husband's next wife. In the month since your death, she's brought home-cooked meals over to your husband 6 times already. She thinks there's no good reason that money earmarked for your children shouldn't be spent on more important things like jewelry or spa vacations. So you should ask yourself, do I want her to get my children's inheritance? That is an issue for about half of our clients who are married. Now, I hope this is an exaggeration. I hope you don't have a son-in-law that looks like this character, but we have a lot of clients that have son-in-laws that maybe don't have tattoos like this guy, but they have a bass boat addiction, or they have an alcohol addiction, or they're abusive. There are a lot of reasons why we need to have our daughter protected from this character. This guy hasn't had a job for a while, and he's going to expect that if something happens to your daughter, he's going to end up with a good portion of what she inherited from you. So you have a daughter, they have in-laws. They accepted 126 invitations from you, and they haven't reciprocated even one time. They love spending as much time as possible at the home you bought for your daughter. They especially like the swimming pool. We joke about this, but it's true. We want to make sure that our daughter is protected from people like this, because while these are fictional characters, we actually have real clients who have a daughter who has real in-laws that are just like this. So this is not an imaginary issue. We have a lot of clients that have children, and on a slide here, it's a son. He's been in a lot of businesses, and every single one of them have failed. He owes $120,000 in legal fees and back taxes. We don't want to leave an inheritance to this son and have that inheritance wasted, and then have him have no financial security to fall back on as he gets older. So giving property outright to your children is not a good solution, in our opinion, and that's why we encourage our clients to create what we call testamentary trust in their revocable living trust to provide protection for those children, to protect from the kinds of things that we're talking about here. Now, to help you understand how this works, I want you to form a mental image. This is a mental image I want you to form. It's a safe. I want you to think of a testamentary trust like a safe. Sometimes I say think of it like a lockbox, but in this case, think of it like a safe, and there's a combination lock on this safe. We're going to talk a little bit about what the combination is in this safe. But what are the benefits of leaving property to where it's held in a safe like this with a combination rather than simply leaving the assets outright to your beneficiary? There are several benefits. One is the assets that are left in this safe are completely protected from divorce. And that protection comes for a couple reasons. One is because your child doesn't technically even own the asset. The assets are really owned by the safe, so that a divorce court doesn't have the authority to take those assets away from your heir and give them to your heir spouse. But the other protection, which I think is probably just as important, is that it eliminates the risk that your heir will end up putting those assets into a joint account with his or her spouse. I find that is just an extremely common occurrence. Whenever people inherit money from a parent, it's just very common that inheritance ends up getting deposited into a joint bank account. It gets deposited into a joint brokerage account. Somehow the other spouse's name ends up on it, and all of the legal protection that it would have had is lost whenever that happens. If we create a trust like I'm describing here, a testamentary trust, we eliminate the risk that could occur, and we do then have the divorce protection we're looking for. We also have lawsuit protection. The law in Arkansas, and I will tell you the law in every state in the United States, is really clear that a third-party trust is really, if it's drafted properly, is really bulletproof from giving creditors the ability to take the assets away from our heir. So you can provide lawsuit protection that is powerful enough such that even if your child goes through bankruptcy, the assets are not pulled into the bankrupt estate and distributed to creditors. It provides immaturity protection. And that immaturity protection comes in the form of having somebody else serve as a trustee. This is not a big issue. This is not as big an issue as it was a couple years ago, but it also provides estate tax protection. And by that I mean to say that if your children over their lifetime should become wealthy enough where the estate tax is an issue for them, then all the assets in this testamentary trust are treated as if your child doesn't own them, and so they're not included in their estate. So I would say that if you have a child who is financially successful, a testamentary trust with these provisions is really, really essential, not only for the divorce and lawsuit protection, but so that your child can then leave these assets to the next generation or the next several generations outside the estate tax system. So, some things I want you to consider as we think about how we would design this safe, this testamentary trust. We have to think about who's going to be the trustee of that. Is it going to be a family member that we're going to name? Is it going to be an institution like a bank or trust company? And there are a lot of those out there. Most of the investment houses have some relationship with a bank or a trust company, either an outside trust company or one that's an affiliate of their organization that can serve in this capacity. Or thirdly, a very common option is to have the beneficiary serve as his or her own trustee. Of course, that's something that that's an option that you would only choose if you were confident that the beneficiary was mature and responsible, because if we draft a trust that has all of these protections built into it, and you turn this trust over to a trustee that is not financially responsible, somebody who won't carry out the instructions that we drafted, then we really haven't accomplished very much here. So, but that is an option. That's actually an option that a lot of our clients choose. And one of the things that's important to know is that if you name a son or daughter to serve as the trustee of his or her own trust, that trust still has all of the divorce protection that we're looking for, and it has all the lawsuit protection, all the bankruptcy protection that we're looking for. So if you have a son or daughter who you have confidence in, somebody that you believe is financially mature and responsible, then there's no reason why you can't name them to serve as the trustee of their own trust. Now, if you don't name the beneficiary to serve as their own trustee, we have to think about some other issues, like how are we going to pay trust income out of the trust? Now, I want to be clear about this. Just because we put these assets into a testamentary trust, put it into a safe, and we lock it up, and we have this combination, it doesn't mean that your beneficiary is locked away from enjoying any benefit of these assets. All it means is that the opportunity to benefit is measured based on the judgment of the trustee and based on how you actually drafted the trust document. And there are a lot of options for how that can be done. We can, for example, in a trust say, and we quite often do say, that whatever income the assets in this trust generate, those assets have to be paid out to the beneficiary. That's an example of a mandatory income distribution. But one of the downsides to that is that if your heir, your trust beneficiary, gets themselves into legal trouble and there's a lawsuit and they lose it and there's a judgment, then what we know is that those mandatory distributions have to be paid out, and if they're paid out and there's a judgment creditor, that judgment creditor is going to be standing there waiting for that check to be cut so the judgment creditor can grab it. And for that reason, I actually prefer to draft our testamentary trust documents so that the payment of income is done on a discretionary basis in the judgment of the trustee. And we actually draft the trust with some flexible provisions in it so that if that situation, the one I described where there is a judgment creditor out there, if that really occurs, then the trustee has the ability to actually use trust assets to purchase things that our trust beneficiary needs without ever having to give the money, ever having to put the money into the hands of the beneficiary. It could come down to something where the trustee actually went down to the local supermarket, went down to the local Kroger store with a trust checking account and wrote checks to buy groceries to put in the refrigerator of a trust beneficiary. We can buy a beneficiary a house, have the trust own it, use trust funds to pay for that. Those assets are going to be completely protected from any future divorce, going to be completely protected from that judgment that we're talking about. So my preference in drafting trust is to make the distribution of income discretionary. But what about principal? I have a lot of clients that worry that if they create a testamentary trust for their beneficiary, that principal is going to be locked up and the beneficiary will never have an opportunity to enjoy or benefit from that. And that just is not the case. What we can provide in a trust is the authority of the trustee to make distributions of principal to a beneficiary. Now, typically, we draft a trust so that distributions of principal are not quite as easy to be made as distributions of income, because all of us who are old enough and have some life experience know that if you spend your principal, that's a little bit like eating your seed corn, and that money is really lost forever. So what we'll do quite often is impose some standards that the trustee has to observe in order to make these distributions to a beneficiary. Sometimes we will draft in language that very specifically says, I want the trustee to have the authority to make distributions to a beneficiary, but I want the beneficiary to really need it. I don't want it to be just capriciousness. I don't want it to be to buy a new bass boat. I don't want to spend principal unless that beneficiary really needs it. So we'll draft in conservative language. I have clients that take the opposite view and they say, I want my kids to be able to enjoy this, and so we make the language fairly liberal. Sometimes we draft in language that gives the beneficiary himself or herself the right to take out a certain percentage of the value of the trust every year. Actually, these provisions are fairly common in trust, and what you'll typically see is that a beneficiary would have the right to take 5% of the value of the trust each year. The idea is that if they took only 5% of the trust, it would take many, many, many years to deplete the trust. I usually don't draft those provisions in. I much prefer to leave it more discretionary in the judgment of the trustee, but I have clients that want to make certain that their heirs are able to know that they can actually enjoy and benefit from the trust while they're living, and so we do include those provisions sometimes. Another question we have to deal with is one that's not immediately obvious, but if you think for a minute, it becomes obvious. If we do a good job in creating a testamentary trust, what that means is that this trust is going to be there for our heirs' entire lifetime. It's going to provide financial security for them for their entire lifetime. It can't be taken away in a divorce. It can't be taken away in a lawsuit. But what it also means is that when our child is old enough now that they're thinking about who are they going to leave this to, we have a trust that has all these assets in it, and part of the thought process is going to be, well, who's going to inherit the assets in this trust? And we have to have that conversation with our clients, because it's our client who's creating the trust currently that gets to answer that question. And so the question is, how much flexibility do we want to give our heirs over who inherits the assets in this trust when they pass? Now, this is something that most clients don't come into the office thinking about, because they're thinking about their own mortality. They're thinking, gosh, our kids are going to be living for another 30 or 40 or 50 years, and this is not anything they've given any thought to. But we have to take a few minutes and think about this, because this trust that we create, this testamentary trust that we create, is going to provide lifetime asset protection for our children, which means that the assets are going to be in the trust whenever our children die. So we have to answer the question, who gets that? So our clients have to think about how much power or how little power they give their children to make this decision. A lot of our clients will say to us, well, at that point, I really don't care who they leave it to. And so we draft the trust language to give the heirs a very broad power to decide where the assets go. You know, and it's interesting. I have clients that say that, and then I'll ask this question. I'll say, "Are you okay? I'm just testing you. Are you okay that if your son died, and he left all of this to his wife, you're okay with that?" And I have a lot of clients who will stop and reflect on that and think, well, you know, maybe not. Maybe I'm not okay with that. Maybe I don't want those assets to go to the new guy that she marries. I would rather have those assets go to our grandchildren rather than go to our son's wife, where we've really lost control over that. So I have some clients who tell me, I don't care what my children do with it, who change their mind after they really reflected on that. We have a lot of clients who will say, I'm entirely okay giving my son or my daughter the power to decide where the assets go, as long as the assets can only go to somebody who is a descendant of mine. So I'm okay if they leave it to their children, and I'm okay if they decide that one child deserves more than another, and they can make those changes in allocations, or if they don't have children, they can leave it to, you know, their siblings or nieces or nephews. I'm okay with that, but I don't want it to go outside the family. I have some clients that say, well, you know, I'm okay with it going outside the family as long as it goes to a charity, but I don't want to have them leave it to somebody they marry, or just somebody who's a neighbor or friend. We have some clients who feel very strongly about where the assets should go, and so they draft these trusts so that their children, their heirs, have no power to decide where the assets go. The assets pass the way our clients said the assets will pass, and that's all drafted into the trust document. But But that is actually a conversation that we have to have with every client. So now we understand that we can draft living trust that provide for the creation of these testamentary trusts when our beneficiary passes, that provide divorce protection, lawsuit protection, bankruptcy protection, immaturity protection, all of those benefits. So you have to be asking this question, this point, why would we not do this? Why would we create an estate plan that provided for outright distribution to heirs, or even create an estate plan that provided for eventual outright distribution? We see that. That's very common. Sometimes clients will say, well, gosh, when they're 30, just let them have it. It's all theirs. But I'm saying if you draft a plan that provides for that, at the point the assets are distributed outright, at the termination of the trust, the assets lose all of the divorce protection. They lose all the bankruptcy and lawsuit protection they have. And so my preference, and what we encourage our clients to do, is to create lifetime trust and put a lot of thought in how they're drafted. So the question I'm asking now is, why would we not do this? And I will tell you quite honestly, in our opinion, there is no good reason to not do this. I will point out that a testamentary trust, once it is created after our client dies, does require an annual filing of a separate income tax return, but in our view, that is a very inexpensive form of insurance. That is the only inconvenience, the only cost that is associated then with having that trust, unless you have hired an outside trustee to serve as like a bank or trust company to serve as the trustee of that testamentary trust. So anyway, there are a few thoughts about how we counsel our clients to plan for the protection of their children from divorces, lawsuits, and bankruptcy.